present our vice, recognize our Vice President Kathleen Fry. For
Lord.
Well, maybe you got rid of it. Stopped.
I hope so.
Okay.
All right.
I was hoping David Allen could join us because he has made a couple of moves where I know he had to do exactly what it is we're talking about.
Yeah, I thought he was going to be here. So
no, he had said he was.
And Stacy.
Cordis.
Yes. What time is it? Oh, it's past time.
Yeah, it's 3:04 by my watch.
I was going. I
And
don't think I have David Allen's text.
I think I do. Let's see if I can't ping him real quick.
Because that's only 2 committee members, right?
Oh, hold on, I do have something.
Well, if you've got it up, go for it, Warren.
All right.
I'll email Stacy.
Is that a set of cacti that are on your shirt, Warren?
Yeah. Silly shirt.
There he goes. There's David.
Got
him. It wouldn't be a party without David.
No.
There we go.
But he's still muted, so that's good.
Yes.
Not for long.
gosh.
I was just opining, David, that you've made a couple of moves which probably uniquely qualify you to speak to some of the issues that kind of remain.
Yeah, no shit.
Well, I can't help it. I'm popular as crap. That's what happens. Everybody wants a piece of this. Come on.
I hear you.
Well, you finally figured out that you can't leave yourself.
Those damn creditors, they'll follow you anywhere. Let me trust you.
All right. Any word on your email, Suzanne?
I just sent it to Stacy, so
okay.
We can probably go ahead.
Yeah, let's do that in the interest of time. I know practicing law moves at the speed of light, so we need to go ahead. But clearly, based upon Todd's recital earlier, we all know that we have to avoid conflicts or even the appearance of conflicts. That's just kind of part of what we're duty bound to observe. And I hope that nobody's got a conflict that we need to kind of work around today. But if you do, I'll leave you a moment here to say yay or nay. Okay, no conflicts. That's good. We can move ahead. You got a copy of the agenda that Suzanne routed around, and I think we've made good progress. Suzanne and I were just saying before everybody joined that there were certain things that kind of came up along the way. I think we're making good progress, and we are dealing with the inquiry of Savage, and of course today we have our namesake of our committee with us. Warren is here. I had suggested when I saw him in Beaufort that it might be good to have him as part of this process, because obviously he fields these kinds of issues in his professional role, and he was kind enough to say, okay, I'll do it. So welcome, Warren. One of the other things that kind of happened in Beaufort, and Davis is not here, but he said, we ought to also consider what you do with retiring lawyers. It's, I think, very similar to what we've been wrestling with, but I mentioned it to Warren. He said, yeah, that's probably something we ought to, also explore. So I think we can do that as we kind of move through these things. But I think we kind of left things, Suzanne, with inquiry 8 and some subtleties there that we need to kind of run to ground. First of all, Well, I'll stop there. Anybody have any overarching things that we need to kind of address before we launch into what's outlined on the agenda that Suzanne put together?
It's
Right.
Stacy's here now, so that's good.
Very good. Welcome, Stacy. Glad you could join us.
Hey, sorry, I had a little emergency, which I will not share with you, but it's a one of a kind.
All right. Well,
No worries.
all better for that, I'm sure.
Okay. It
Okay.
involves
Well,
the prison.
yeah, and David, you can, I think, speak to this as well. But we were kind of wrestling with, how far back do you have to go if you're going to be sharing client names or descriptions of matters? And the question is posed here: is a departing attorney entitled to a list of all his current and former clients? And in some respects, you could say, well, if you've got information that's kind of unique to a client, if you haven't represented them for the last 2 years and the matters are all inactive, you could still have very important information that could be problematic, even though you're not currently working for a client on their matters. And also, hard to believe, but David Allen's actually practiced longer than I have. And I would bet your list of former clients is pretty prodigious, David, if I were a guessing man. And do you go back 40 some odd years or 38 years in my case? That's a lot of water over the dam for sure. But I'm gonna stop talking now. But I do think the gist of what it is that we got to do is make sure that somebody that is leaving a firm does what's necessary to ensure that the client isn't going to run into a conflict headlong and have problems. So anyway, David, I'll let you kind of open up if you wouldn't mind just telling us about your experiences and what you have seen in connection with the couple of moves that you've made over the course of your career.
Yeah, I mean, I think that the problem, as Craig set it out, is really a pretty knotty one in terms of how far back you have to go. I mean, I was at Parker Poe for 30 plus years, and they probably had the capacity to generate a list of clients for whom I had worked for certainly 25 of those years. I don't know when, maybe for the whole shooting match, but is it reasonable to expect that to happen and for the departing lawyer or the new law firm to engage in that kind of an in-depth screening process, particularly where what you're really looking for is not a conflict with a current client. If I joined Anna's firm and she gave me a list of the current clients of the firm, I could look at those and know, if I had any overlap with those. And similarly, I could give her my list and she could look at mine. The problem becomes when I'm there, I have accepted a position with Anna's firm, and either I bring a client in the door or a new client comes to me, and it ends up, or let's put it this way, this is the example that happened to me in the materials. I come into the Anna has a file, and I come in, and lo and behold, 9 years ago, I worked on a matter in which I represented a current party that is adverse to one of Anna's existing clients. And none of us know that. And it would have been, it's hard to know how you screen for that. The real life example, and it's a reported opinion in South Carolina. And what happened is when I joined Nelson Mullins, I was representing a company called Copart, and we'd been sued by a landowner in Columbia, and over a Clean Water Act matter. And so, and the case was in 3 or 4 years of litigation. We were ready to pick a jury in 2 months before the other side moved to disqualify us. The fact that we may have been kicking their ass, I think, had something to do with that, but be that as it may, they filed a motion to disqualify us. And the conflict was this. I joined Nelson Mullins. I made the complete disclosure, including the names of all the individuals that were involved as landowners. Another Nelson Mullins partner who had also lateraled in had represented one of those folks 5 years before joining Nelson Mullins. So get this, he joined before I did. 5 years before that time, he represented Craig, let's say, okay, on a matter that was related tangentially, or same dirt in Columbia. And he had represented Craig on that. Now, Craig is suing my client. And it's now 7 or 8 years since the original litigation was involved. And he, the other lateral partner, had forgotten the names of the individuals. They had been run through the Nelson Mullins conflict system, through the computer, but of course they had never been clients of Nelson Mullins. They had been clients of Warren in his prior life over at Bailey and Dixon. And so he did not run all of his prior clients through the Nelson Mullins conflict system. And if he had, it would not have been a conflict because I had not yet joined the firm. So when I joined the firm, we did and Judge Anderson says this in his order, you know, we made full disclosure. They ran it through the conflict system, ran it through the computer, no conflicts, kept the case. And so then it turns out, as a result of discovery sanctions against the landowners for failing to turn over some documents, they turned those documents over, and lo and behold, there was correspondence from Warren when he represented them. And so now that guy's a partner at Nelson Mullins. I'd never met the guy, didn't know him from Adam. I couldn't have told you whether he was, you know, Warren or Stacy. Didn't, you know, never met the guy, never talked to him, never built a tenth to the file. Anyway, Judge Anderson said that we were disqualified, and he disqualified us. And South Carolina does not have the ethical screen, which Judge Anderson called a Chinese wall, and I understand that's not the term we use nowadays, but they do not allow for ethical screens in South Carolina. And as a result, we of course said, as federal court, Judge, you do whatever you damn well please. And lots of other states do that in the Fourth Circuit. And but he decided that the better course of valor was to disqualify us, much to the chagrin of me and my pocketbook and our client, who then had to pay, of course, to get another firm completely up to speed on a case that was going to trial in a month. That he did continue it. But, you know, I saw no way, in looking back at it, there's nothing that we could have done to provoke that conflict other than when Warren joined the firm 5 years before I did, or whatever it was. It somehow loaded every one of his prior clients in there. And for me, that would have been impossible. I mean, as Craig said, you know, you've been practicing law 35 years. I can't remember them all. And the fact that a computer listing may show I represented Acme Enterprises, but the sole stockholder at Acme Enterprises was Warren Savage. He may or may not have been disclosed on the, you know, on that file, or he may now be the sole stockholder there. I don't know how you screen for that. And Judge Anderson said exactly the same thing. He said, I don't know how you could have prevented this. He said, this is a cost of, basically, he said, this is a cost of Nelson Mullins buying lawyers and putting together a firm that used to be a 50-man firm and is now an 850-man firm. And that's the price that you pay for getting big. And I think that's terribly unfortunate. I think that's also wrong. But I could understand his doing it. We did have an opinion, of course, from the chief ethics officer, or the guy who teaches ethics at the University of South Carolina, also may have had the South Carolina Deanna Brocker We had an affidavit on our side that said there was, that the thing to do was to set up an ethical screen. All of this kind of crap. Shockingly, the plaintiff had an expert from some other state, like maybe North Carolina, that opined that this was in fact a conflict that should lead to our disqualification. But it was unfortunate. It did piss me off because I did not see any way that they were harmed because of it was client confidences that they were worried about. And Judge Anderson basically said the plaintiff feels like this is a problem, and I'm going to err on the side of the appearance to the plaintiff. And it's possible one of us reminded him that appearance doesn't appear in the rules, but he still said that sort of was the way he came down on it, was that it was the perception of the plaintiff as he said it, whether it was true or not, but that as he said it was that there was potentially the fact that he couldn't remember who his lawyer was, and that the two matters only involved the dirt, did not involve the same kind of clean water issue, was somehow got lost in the exchange. Anyway, so I told Suzanne she could share that opinion with the committee. I don't know how. I mean, I'm not embarrassed about it. I don't think we did anything wrong, but it's a conundrum. And the only way, and this is when I saw how long you have to go back, if we had gone back, no matter how long I went back, there was no way to discover this. The only way would have been when Warren joined Nelson Mullins, was if he had dragged every client of his through the computer system. And then they were there when I joined, and I just don't know how feasible that really is.
Taken to the absurd extreme, every single lawyer at Nelson Mullins brings all their former clients and then because you're not allowed an ethical screen, you take on every single one of the 850 lawyers' former clients that's terrible. I'm glad we got an ethical screen. That makes no sense. That is.
Well, the touchstone is what you do that is reasonably necessary. It doesn't say every conceivable effort. The standard isn't that high. And I understand, David, the predicament that you faced. But if I were to ask you two questions, one would be, how many years back did you go, either when you joined Nelson Mullins or your prior law firm after Parker Poe, Hedrick, I guess?
Yeah. I didn't go back, I did not go back far at all. I knew who my clients were and had been, but what that means is I knew the top 50 clients that I'd had for 4 or 5 years. If I had a random client that came to me for a one-off, which lots of us do, 2 years ago, the chances of me actually remembering that I had represented Anna in a matter that was a one-off for her and remembered her name would be possible, but not likely. The trouble would be it was really when it's just how far back. And I think that the way you've got to do here is to allow lawyer mobility at the same time as you have to protect client confidences. And I think that's the real question: is how do you where is the line? Is it, and I guess a reasonable amount of time is all we can probably say. There's no hard and fast rule, because if it's a gigantic issue that happened 3 years ago and it just is somehow, not in my consciousness, then you should remember that, and that doesn't really matter how long ago the time was. By the same token, if it's the Anna situation, unlikely that a client confidence from let's say a slander action against Anna, and I represented her, what client confidences would I ever have in another piece of litigation that would involve that. I think that's it involves all those kind of issues. It's the knowledge, the type of action, and the potential for future litigation, I guess.
Yeah, I think it's going to vary from attorney to attorney and from firm to firm. As you said, some firms may have the resources to go back 40 years, others may not. It would be a Herculean task to try to assemble all that data. So, maybe add reasonably necessary under the circumstances or something like that. I don't know, but what's reasonable to me might be very different than it is to Anna, for instance. Just saying. Anyway, anybody else have any thoughts or insights or ideas about how to address this conundrum?
To me, inquiry 8, and we're still talking about inquiry 8, maybe posture it more. The only problematic part to me is departing attorney entitled to a list of all his maybe sort of a softer, should law firm make available as reasonably requested by a departing attorney a list of current and former clients, and does that make sense? I mean, because of an attorney leaving a law firm, he may not want all his former a list of all his former clients, but the way he just made Needham as requested, but the way we put it here, if he just asked for it, then the law firms has to go give it to him because he's entitled to a list of all four. I don't know. Am I getting too in the weeds there?
I think that's a good point, Warren, because the way it's worded, you absolutely would have to deliver a list of every client that attorney has represented since that attorney joined the firm.
Right.
It's probably beyond the pale. But kind of parsing it out the way you've described it gets to a better place, in my opinion.
And maybe, if I'm the departing attorney and I'm leaving of my own accord, I'm probably making a big old list of my former clients before I leave, right? Whereas if I'm a departing attorney because I've been fired, that's a different scenario, right? I mean, that's then maybe I do need you to just go make me a big old list because I don't have any access. I don't know. It's I kind of like leaving that one a little more just give some guidelines on what you should do than trying to give specifics, because there's a lot that might play into that.
But the problem I have with that is that this is one of the issues that lawyers fight about when there's a firm dissolution. And if the lawyer that's departing doesn't feel like he should have to give all of those names, it's the firm that he's going to that's going to be hurt. It's going to get disqualified in the future, potentially, if the lawyer that's leaving one firm and going to the other doesn't provide the list of all his former clients. Then what happened to David's firm is what could potentially happen, is potentially the result of the lawyer not turning over a list of all his former clients, right? Isn't he then setting his new firm up for potential disqualification?
That's exactly right. And the real question for me is also a logistical one, is if it's and I'll pick on Stacy because her firm is the smallest one I think that's on the board right now. If you have to produce that list, if that were the case, then I don't know how if you don't have that list, this says you're entitled to a list of all of your former clients, and so you would, I think Stacy would, when somebody leaves, she would have to create that list, because it would be, otherwise you're imposing one set of obligations on Park Repos with its computer system and another on, on a smaller shop.
Well, I can't imagine, since I've been, let's see, 4 firms in my career, that you wouldn't have that list with conflicts. I mean, I don't care how small you are. We have lists of every client. I have probably lists, maybe not from my first firm, but certainly within the last 10 years. Every client that I've represented. Now it gets more convoluted when it's landowners, like you were saying, and there are multiple members of LLCs or corporations. But I don't think that really. I mean, I think small firms have conflict lists, just like big firms, and should be able to provide that. So,
I mean, I think that's required under Rule 1.7. You're required to come up with a conflict system appropriate to, check for conflicts in your area of law. So, and especially now when everything's computerized, I just don't feel like it's that big of a burden to produce a list.
but I think we could revise inquiry A as opposed to entitled to is departing lawyer obtain a list or something, as opposed to directing it. Would that soften it? Is that what you're saying, Craig and
I
David?
think so. It's a black line test right now. It's all current and former clients, right? That's what you get. That's what a law firm is obligated to do. And in your case, if you've been at 4 different shops, and maybe you've done a great job of keeping that list together as you've made those transitions, but boy, that could be a very difficult thing. Is it all your current and former clients at your current shop? Is it going back since, you got sworn in? It can be difficult, I think, but I certainly hear what you're saying, Suzanne. If you've got the computer capabilities, maybe it's not as hard to do, but I think that there are things that happen in terms of transitions made by lawyers that could make that very hard. Just saying.
Yeah, but the person, who's going to get hurt by this is the new firm.
And potentially a client or client.
Right, because they're going to
Get
get disqualified.
Yeah.
Well,
Potentially.
I mean, potentially, North Carolina, hopefully with the ethics.
I mean, we have
screening
screening, which
sometimes,
would have
but-
helped out a lot in David's
Yeah.
case, but you have to have time, you have to screen in a timely manner, so you have to know about the conflicts in order to set up screen.
Maybe do it sort of, should the firm provide any information necessary for the departing lawyer to conduct conflicts checks for current and future clients at his, wherever he goes, something like that. I mean, that at least that gives you, and then we say, yes, of course, every lawyer has to be able to do a conflict check, and to the extent that the departing lawyer needs any information to do conflict checks at any new firm he goes to, or for future purposes as new clients come, he ought to be able to get that information. I don't know.
Well, maybe this line that's in the middle of the opinion can get moved up toward the top, so that this extent reasonably necessary to detect and resolve conflicts of interest is a modifier to the word yes, because the word yes indicates, again, something that's absolute as opposed to something that might be qualified.
I mean, I think I think there still needs to be some sort of a reasonableness test on here, because we have those all over the place. There's also the potential that, I mean, even in a client confidence, if things have become public knowledge, over the course of time, then it's no longer I think, no longer a client confidence material. if it's the kind of thing that is now in the public domain. I don't know. I mean, I think it still is remarkable to me that if I have right now, the two hypotheticals, if right now I change law firms again, I've got to go back to Parker Poe and get a list of all of my clients at Parker Poe. I've been gone from there for 15 years, Greg. I don't know, 20 years.
Yeah.
And, you know, and get that as well as the list from Nelson Mullins and the list from Alan Chesson, and then take that with me. And the other that's a potentially more troubling hypothetical is, and I'll use again Craig's firm. This lawyer there named Steve Hunting, who was a Parker Poe partner and probably 10 or 15-year partner, went in-house with Duke Power. So there was no, you know, when he made that move, there would have been no reason to do the kind of conflict check we're doing here, because he was not going to another firm. It wouldn't be representing other clients. Duke was a client of his when he was at Parker Poe. He popped back out into the private practice. And let's say he had worked for Duke for 10 years, and rather than returning to Parker Poe, which he did, he decided to go work for, you know, Pointer Spruill. And so he then has to go back, I guess, and get the 10-year list, the 10-year-ago list from Parker Poe, and take that with him to Pointer, and probably do that before he, you know, so that Parker Poe knows before Duke knows that he's going to Pointer. And I'm not saying we should be protecting the lawyer here. I just think that there is some sort of reasonableness test that should come along in here. And I have trouble drawing where that line is. I just, you know, I guess we're counting on the ethical screen to take care of most of these problems, because maybe I'm just prejudiced given my own personal experience. That's the prism through which I see most of life. And that one, you know, so I do think that was, it's hard to deal with it, particularly given the significant passage of time when you have to rely on people, you know, recreating their client lists.
I still come back to, if you, regardless of what you do, if subsequently it turns out you represented somebody, you could still get disqualified for that.
Good, that's right.
Oh, of course.
But you also, you know, Suzanne, you also, I mean, as Stacy said, she's like me, she's been in a couple of different law firms. If you got to go check the list with the new firm before you do it, then your old firm knows you're leaving. And, you know, what I've done when that was happening is I sort of made up my own list of what I thought were my clients. I had, of course, billing records, and you can go back some distance because you know who your clients are. But I couldn't, when I moved to the Parker Poe firm, or when I left Parker Poe, or when I went to Nelson Mullins, you know, I did not request a list of clients from my old firm, my current firm, to shop with my new firm. I just did what I thought, what I could remember off of that. Because otherwise, you do, I think, significantly limit lawyer mobility, which is something we don't want to do.
So you didn't have access, now this is something new to me since I haven't been in a large firm, you wouldn't have had access to the clients, like in the database at Parker Poe? Craig, you're there, right?
I would have that. I could generate that very quickly.
Okay.
Somebody would probably know that, Craig, if they wanted to, or could know that.
Right. Nope. I agree.
Oh, that he downloaded it, like if they were looking.
Yeah, they would meet.
Okay, I
Wow,
see.
you know.
The big brother, yeah.
Like just as an example, if somebody's all of a sudden kind of accessing all of their documents, it's something that's very suspicious, and that can be detected.
Downloading all my forms. Yeah, boy.
That's right. Yeah. Well, I would suggest this. We definitely spent a long time on this, but I think it's because it's not cut and dry. It's something that's a little amorphous. So I think if we can maybe ask a privilege of all of you to maybe take a look at a way to tweak the language to perhaps inject this reasonableness standard, knowing that we've got the screening that can take care of some of these ethical issues, but perhaps Suzanne and I can work on crafting something that I think addresses the concerns that many of you have raised, but at the same time, kind of carries forth the spirit of this, which is, hey, you got to do what's reasonably necessary to figure out if there are conflicts, because it can hurt the lawyer that's making the move, the firm that he's moving to or she's moving to, and the clients that she's taking with her, or the clients at the new place. So it's a thorny issue. There's no doubt. That's why we spent 30 minutes talking about it, and why it was still kind of on our list of things to do. But that would be my way to try to untie this Gordian knot and get to a point where we're happy with it. But Suzanne, does that?
Yeah,
pass
I mean,
to you?
that's fine. I was not able to find any resource anywhere that talked about a specific time period.
I bet you're not going to find it because
You're not
of
gonna find
the
it.
issues that we're talking about. Right?
Yeah.
Yeah.
I think it's
Um,
more just a warning to the lawyer and to the firm not to make it unreasonably difficult for somebody to do a conflict check and to know who their former clients were, and that they need to make that information available so that they can go where they're going and do what they're going to do. And so everybody can get it.
Well, I asked Warren earlier, and he didn't know why I was asking him. I asked him if Lawyers Mutual had a specific time period that they recommended for conflict checks, and what Warren, what you said to me is, well, confidentiality, the duty of confidentiality lasts forever.
Right.
So, that goes to saying that you need to provide information back, forever. There's not, that information
If
doesn't-
needed. I mean, yeah.
Yeah.
I
agree.
mean, it's not like you can say 3 years. Okay, well, if it was 4
Right.
years ago, then that's not going to be a conflict, because it is going to
Right.
be, potentially
Right.
is going to be.
I mean, to David's case, like, what was that? That was
Like between-
representation meant 5 or 6 years ago.
5 or
right?
6 years. Yeah.
I mean, that's difficult. Yeah.
I just, I'm not sure where to go with it, honestly. I'll look at it some more.
Well, I'm just stunned that Deanna hadn't called up and, chimed in and told me that I was, a rascal or a saint, one or the other. She knows the truth. I'm neither, but, or both, depending on the day.
Well, I do have some thoughts about this, and why you're not going to find anything about a time frame is because I think this is creating a new duty that hasn't been there before. And the reason why I say that is because, having sort of advised both sides, departing lawyers and law firms, nobody has asked me how far back I need to go to produce. Nobody's looking at former client matters. What they're looking at is, okay, what is this lawyer who's moving handling right now? And is that going to prevent him from making that move? And generally they've left 1.9 and 1.10, the lateral hire rules and the screening rules to kind of take care of if something comes up later.
Yep.
Rather than having to try to do a conflict check and anticipate what might come up later, they're trying to make sure that the lawyer who's moving right then isn't going to be booting clients out from either side. I mean, that's generally. And I will tell you that the only lawyers who have ever asked me about, well, I want to see my former client list, are the ones that want to tell them that they're moving so that they can say, hey, if you need anything, here's where I'm going to be. It's more of a solicitation issue. Or advertising issue. It's never been a conflict. I don't know. I mean, I just don't know any lawyers that have tried to go back in time. And usually they're relying upon the lateral hire and screening rules. And they're pretty good. I mean, they're very clear. You don't walk out of a firm with your baggage of everybody that the firm has ever represented. You're walking out with your own baggage. And so maybe you need your client list to have your own access to it, but you're not giving it to your new firm so that they can do conflicts for somebody who you've represented 20 years ago, 10 years ago, 5 years ago. They're going to be looking to make sure they're not going to be knocking any of their current clients out because of something that you're handling right before you left. So it's the language. What I sent you, Suzanne, was that language, and I don't know if it was a treatise that you had pulled from about needing the former clients. If you look at the language closely, they're talking about the clients of the departing lawyer who have become former clients when the lawyer leaves, and those clients don't move with that lawyer.
That's an ABA opinion.
Yeah. So, I mean, I think we need to be careful because we're really creating a new standard by requiring lawyers who leave to give former client information, confidential information, to a new firm. Anyway, that's just, I know I'm sort of like completely, my opinion here is completely the opposite of where you guys are going with this, but that's just my sense.
I'm glad you spoke up because I'm with you because I feel like we're trying to solve a South Carolina problem. And we've got North Carolina rules that take care of this extreme case here. And if we try to solve this problem here, we don't need to. And like you say, there's very, very little chance that something like this would happen in North Carolina to David and the firms here because of our rules. So why? Yeah, I like your thinking there, frankly.
So then would we say they're not entitled to any former clients, only current clients?
Well, I don't know about that.
I just like the idea of more for conflict purposes, making it information available as necessary, that is reasonably available. Like you say, I don't want to give David, when he leaves my firm, all the former clients so that he can then turn around and market them to come to send all his new. I mean, that's a not for conflict purposes. That's 100% reason.
So in the draft that we have now, if we just take out the yes, is that what, I mean, basically you guys are just saying you have to provide what's necessary.
Suzanne, can I make one other suggestion? Inquiry 7 and Inquiry 8. Inquiry 7 asks about, are you entitled to contact information for current clients?
Right.
Can we make that one all about a list of and contact information for current clients? Like move the list of current clients from Inquiry 8 to Inquiry 7, and then just make Inquiry 8 about former clients and ask it in a bit of a different way. Lose the entitled.
Yeah.
Get rid of the entitled. I don't like that.
Yeah.
Right.
You're entitled, Warren.
Silver spoon, baby.
Yes, that makes sense. Yes, that makes good. I think that's a good suggestion.
Just so you know, Warren, I don't have to market to your clients. They're coming like that.
Oh, I know.
They're just automatic.
Actually, the rest of these folks don't know how true that is.
Well, is it worth, just for the good of the order, making reference to the screening element that we've been discussing? Because that's part of the material you provided to us, Suzanne. I think that might give some comfort to people when they're looking at what is now just in isolation without any reference to 1.9, 1.10, or anything else. I think that might be worthwhile.
Good point.
Yeah.
Okay. All right.
That makes sense.
We'll go to the drawing board on that for sure. Okay.
Okay. I think those are good
I'm
suggestions.
sorry, I didn't mean to throw a grenade in here. That case was, it's always been bothered me, and I thought that Suzanne and Craig ought to know about it because
That's good.
it was something it blindsided me, and so I just thought we ought to.
Well, plus I just think it's a really good look at how the court looks at a conflict scenario. I thought it was interesting to read it.
Yeah, me too.
We know how we look at conflicts and ethics and discipline, but I just thought it was interesting to see how the court kind of parsed it out. So thank you for letting me share it.
So it showed what can happen at an extreme point. And it's really, I think, something that tempers our thoughts about all this for sure.
Yeah, because we kind of look at it like it's not theoretical, and that
Yeah, this was real
that was
world.
a real life example, which I
Yeah.
thought was really helpful to look at.
We feel for you, David, for sure. Okay.
It sucked.
Sure as hell did.
The word, yes, it did.
Had a hole in my schedule. You know, I was supposed to try this case. We got disqualified. They filed a disqualification motion of Labor Day. We were supposed to try the case October 1st, and it was going to last 6 or 8 weeks. And I had a real easy fall as a result of that, because I planned to be in federal court for at least 6 weeks in the armpit of the world, Columbia, South Carolina. But then it was like, what the heck am I got to fill up some time. So a lot of client work, a lot of BD.
All right. Well, Yana, you've done some good work, and I want to get to that in a second. I want to take some things that are kind of low-hanging fruit and go ahead and knock them out, and then we'll come back and do what we can on inquiry 6 before we need to disband. But we got some sample notice letters. Warren kind of led the charge by including one in the inquiry of Savage. And then
David sent one.
Provided some, well, it's really a tweak of a set of Parker Poe letters to Suzanne. David sent some in, and I think we probably got enough of a base right now where we can create those for your consideration and have those available to you for review and comment before our next meeting. So unless anyone has an objection to that, that's how we'll roll on those samples. But I think that's a good service that we can provide to the bar so that they don't have to create something out of whole cloth. It'll be a good template, I think, for folks to use. And I think, Warren, when it comes to the retirement issue that you and I talked about, I think that's very similar to a departing lawyer when they're going to a different firm. I guess if David decides to retire between now and when we meet next, he probably needs to communicate that. He definitely needs to communicate that to his clients, and they need to know they can stay with the Allen Chesson firm, or they can come to Parker Poe, and I'll take great care of them, whatever. But anyway, I think that it probably is something that doesn't bear a lot of discussion in this context. I think we can maybe deal with that in the context of the sample letters. So anyway, unless somebody objects, why don't we use that as the platform in our next meeting to talk about people retiring?
I do want to make sure that we are like, Craig, if you retire from in the middle of representing a client along with 4 other attorneys at Parker Poe, if you retire, Parker Poe doesn't, all they need to do is tell them that, hey, Craig's retired, but the 3 of us are still here. They don't have to do and you have a choice to go to any other firm and all that stuff, right? I mean, it's just a retirement announcement to make sure they know that you're not on anymore. Am I wrong there?
Well, what if I'm the only person that practices ERISA at my firm? A very specialized practice.
If there's nobody there and they hadn't been, and I guess my point being, if there were other attorneys at Parker Poe that were working on that same thing with you, that same client on the matters that you were working, I don't see why the Parker Poe has to tell them that when you retire that they can go somewhere else. Can't they just say, here's a retirement announcement, come celebrate Craig's party? I mean, that's right. To me, I don't know.
It will vary depending on the
different.
I think. Yeah.
I tell lawyers they do have to send that letter. That
Really?
Yeah.
Inform them of a choice.
It's just the same thing as if you're leaving to go play golf all the time, or you're leaving to go to another firm, or you're leaving to go to work for the government. I mean, that you can say, I'm leaving. These 3 other firms, these 3 other lawyers can work on your case, or you can get new counsel.
I guess my point being, continue to work on your case. I'm talking about, I'm not I mean, if Craig's leaving and he's the only attorney that's been working on it, maybe that's one thing. But if Craig and me and David are all representing the client, I don't know.
Yeah, they may trade up when I retire, right?
Well, there you go. I guess. I don't know. We don't need to get into that here. Maybe that's another
Okay,
opinion.
we'll address those concerns and make that part and parcel of our next get together. Then on the last thing, and we'll see how far we can get here on inquiry number 6. I may be a ship at sea here and be the Lone Ranger, but I didn't know if I were sitting there trying to figure out, okay, I've got a partner who's going to go open his own shop or go somewhere else, and I know that he's got some impairment issues.
Oh, we're going, is
How
that
do you?
6?
Yeah, this is in 6. I'm kind of going backwards
Wait.
here.
Hold on.
Um,
Okay. Sorry, I
yeah,
would
I
think of
thought,
a different one. Sorry, hold on.
I thought 6 was about the cherry picking.
I get there's
It
two.
is.
There's
There's
two that are in
Cherry
6.
picking and impairment. And basically, we got some good information just right before our meeting about issues on cherry picking and some language that's pretty strong about not having the flexibility to just diss a client because it's not as profitable as some other client. But we've got some language about that, and if we can share that, I think you got that material. Suzanne sent it right before the meeting, but I'm just thinking that maybe we can deal with the impairment thing more quickly than the other.
I don't know what else we can say about the impairment issue, honestly. I put in there what we said in 2013 FEOA. We tell people they got to be careful about what they can say, but I don't know how specific. I don't know what else we can put in there, honestly.
Something in there about you got to have actual knowledge. You got to have some reliable source for the conclusion that somebody's impaired. And I think you got to be very careful about what you say, what you
Well,
disclose.
we say
may
that.
know, yeah, you may know because you got information about a diagnosis that has come, and you don't want to be too forthcoming because then I think you may, and I'm no expert, run afoul of HIPAA issues, and you got to be, I think, very guarded. I think there's a duty to disclose, but boy, it's fraught with danger. I think that's my only point, Suzanne. I don't know what poll star you guide by. If I were having to write that letter, I'm not sure what I'd say.
But there are instances where you would feel 100% like you needed to tell the client that they should not be going with this lawyer. I mean, it's to protect. I mean, it's to protect the client. You're trying to protect your own. You're trying to protect yourself from getting charged with slander or something. But
it's a sticky wicket. That's all I'm saying. And,
I mean, I feel like
really,
it's a derelict of your duty if you weren't to say anything when.
If somebody was leaving my firm because I thought they'd been stealing stuff, I would feel compelled to not tell the clients, oh, you have the choice of going with the thieving lawyer or staying with us. I would feel
And if you know they're under investigation, that's a little bit easier if it's an investigation that's public, then you can say that. I think it's harder if you're just concerned about a drug issue or a bipolar issue or.
I wouldn't get any more depth than we already did in that previous opinion about attorneys with.
Okay, well, what would you say? What would you say, Warren? You got a guy or a woman who can't remember stuff,
right?
And they're going to go out on their own. And what are you going to say to the existing client about that?
I'm going to say call Lawyers Mutual and try to get I mean, I think to give the exact language here in an ethics opinion would be very difficult. It's more that you need to be very careful about recognizing, if a lawyer's leaving because the law firm doesn't think they're competent any longer because of mental deficiencies or cognitive issues, then the law firm needs to be careful not to say you have the option of going with that attorney, period. It should say there, and I think that prior ethics opinion, Suzanne says you got to go through that, but doesn't try to dictate what needs to be said there, because that is such a fraught thing. It's
And it's,
case
we
by
do,
case.
we do cite in an ABA opinion that says when providing a client with information about the departed lawyer, firm lawyer must be careful to limit any statement to ones for which there is a reasonable factual foundation.
And leave it to the lawyer to do right and call, you know. I just, to get any deeper than that, Craig, I think would be very difficult. It's like
Yeah,
when
that's-
people call me up and ask for a, you know, do you have a conflict waiver form that Lawyers Mutual can give me? And I go, hell no. Every conflict is different. You got to be very careful. You're going to have to actually take the time to sit down and explain why there's a conflict and what the potential consequences are if you sign this waiver, and yada, yada, yada. It's not a form for me to give.
I understand all that. It's just such a great thing. I'm not sure what you do. Do you specify anything that you've seen? Do you not go there because of the issues it presents? Maybe the guys or the gals on a new med and it's all of a sudden transformed them. I'm not sure, but it's a morass, I think.
Well, but
it's just my
I think the
opinion.
way it's drafted says you communicate the requisite information that are not misleading or disparaging. And then later on that it must be careful to limit statements for those are reasonable factual foundation. So I think we've covered it. I mean, don't you think, Suzanne, that this,
I feel fine about what's in there, but I'm happy to
I wouldn't put it in writing. I mean, I think that's the key. I don't know if I'd put it in writing. How would you, can you just communicate it out?
Deanna, what you,
Well, I have a question, and maybe this is, and I just haven't studied it enough to know, but if you feel like a lawyer has an impediment to competent practice or whatever it is, maybe a substance abuse issue or whatever, and you don't think that they can handle a client matter, is it okay then to just not offer, in other words, not say anything, but not offer that person as a choice if you know that it would be harmful to the client for the client to choose that person?
Was there an off-ramp
so
contemplated by that opinion or that language that we're referring back to in 2013?
So to me, I think Deanna, that 2013 is going to put a little more of this is a current client of the firm, right? And if they know that client is making a bad choice by going with that departing attorney because of what they know about that attorney's condition, I don't think they can sit silent and
what if
say
the
nothing.
departing lawyer talked to the firm and said, look, I'm willing to not be a choice.
Yeah,
that's okay. I think that's
would be
okay.
fine.
Or the firm
Yeah.
says, either I can tell them what's going on,
Oh, yeah.
or we don't give you as a choice, and then
Right.
that'd be okay. Okay.
No, I think
I'd
that
be good with that.
yes, I've talked to people about that before, and it's like, if the attorney realizes that they're having issues and says, yes, don't put me as a choice, then that's fine.
I mean,
Because they've admitted that they're not competent or have the resources basically to continue the representation, which is one of the things you have to look at when you're considering which choices to give. And if the firm and the departing lawyer agree that the individual doesn't have the mental resources, then that you don't have to list him as a choice.
I think that's the easy one. I think it's where
Yeah, that's the
Brett
easy
thinks I'm
one.
around the bend, and I don't think so. And
Right.
I think that's the tough one. I think it is fraught with peril. We have State Bar in the last 2 years has disciplined folks for telling clients they shouldn't go with lawyer X because of his or her inability to handle a matter because of a current situation with them. And I think that the bar was right in that situation because of the motivation of the lawyer in trying to do that. But at the same time, you know, that is the problem that you have here is, you know, the fact that a 30-year-old thinks that a 70-year-old who's a little slow is impaired. A 60-year-old might not think that 70-year-old is impaired. And I just think that's you know, it's such a subjective thing when you don't have a diagnosis, when it's just like, because I've been in meetings with, you know, with Ed, and boy, he's losing it. And we tried to deal with it. I remember when we went through that thing in 13, and it was difficult.
Right.
That
And
very
I
issue.
think y'all spent a lot of time on that opinion. I think it's a really good opinion. That's why
It's a great
I
opinion. I
basically-
love it.
I basically took the language exactly from that opinion because I thought it was really well.
It's hard because it's in the eye of the beholder, and they're always subject to the motivation question. Yeah.
And I mean, maybe I can put something in there about intent or motivation. I don't know. I can look
Well,
at that.
And I was just looking at does the Lawyers Assistance Program offer any insight as to when, you know, I don't know if they've had any, if they offer any assistance as it relates to people, like, for
No,
instance,
they don't.
They don't.
Well, I'll tell you, we had a case where it was a lawyer up here in the western part of the state that was
Mhm.
not doing well. It was really, Brian Oten did a great job, and she came to my office and he helped facilitate her to shuffle her off to Buffalo, but it was very much ad hoc, and it didn't, and I've mentioned before, like, why the lawyer assistance program doesn't also address the issues of just the older lawyer, and it just hadn't gone anywhere unless Suzanne can add more info. There doesn't seem to be anything. So she got it was really sad because this lawyer got like a nasty gram from the Fourth Circuit clerk about when the state bar told the Fourth Circuit she was now on disability status. And this is no fault of the state bar. The Fourth Circuit shot her this nasty gram that said, like, you may know. It was just mean the way it read. And of course it upset her. And there was all this, you know, so there is no cohesive way I know of to deal with lawyers as they kind of age out. And it seems to be, it's sort of just catch can right now. That's my two
I
cents.
thought we were working on committees for that, but
Well, we were, but my knowledge was we floated it and it just kind of flopped. I mean, if something happened, I don't know about it. But I mean, you know, so, and I remember thinking, gosh, with these boomer lawyers, no offense to David Allen, you know, they're going to stick around till somebody pries their cold dead hand, some of them from their desk. So it's going to come up again. But anyway.
But
David, if your fictitious Ed is my current law partner and he wants to go join your firm, do I need to tell you about Ed's problems?
I don't think it's an ethical requirement that you tell me that, but I would hope that you would.
well, and forget age, but what if they're going to rehab and you know it and they're going to be gone? You know, I think that's information that's necessary, right? To be able to represent the client.
Yeah.
But didn't
Rehab
maybe
works sometimes.
kind of steps. I don't know how if LAP's involved in the rehab, they have their own, I don't even know, rules and ways they handle that. Am I wrong? So that's a little different again, because there's already sort of a systems, isn't there, Suzanne?
I don't know how LAP works, honestly. They're completely separate from us.
But
Yeah.
if
But
you
I would say, Stacy, that would be a case, if somebody's going to rehab, that would be a case where I would hope that lawyer would say, you know what, I'm not in a position to take these clients right now. I'm
I
going to
would
be
too.
gone.
that's
And if
usually part of the contract that LAP has with the person is that
Correct.
they have to have someone else sort of take over their practice or, you know, shadow them or whatever. A number of us have served that role where we would shadow somebody because LAP is facilitating treatment, but you know, they're also, if the man or woman's not actually an outpatient, you know, and they're going to still do something, somebody's got to be watching them. LAP does not have the resources to do that themselves.
Don't they pair them with a mentoring lawyer that they have to meet with?
Yes.
I've had, yeah. That's
But
what I
anyway, hopefully
Right.
that would be one where the lawyer and the law firm would agree on what to tell
Right.
Correct.
the
That's
client.
why I think it sounds, I think it's I think it covers. what
Maybe
we-
I'll try to add something in there about hopefully they would agree on
Mhm.
And it maybe does say that. It might already say that.
Well,
I think
I hate
that's-
to end on a supercharged note, but that's this is just one that hit me in a way where I'm wondering, okay, what do I really need to do here if I'm trying to deal with a set of circumstances that's this problematic? And we can kind of pick back up there. And I know I'm mindful of the hour. In fact, we're about 8 minutes over. But I would encourage all of you to take a look at what Suzanne circulated pretty close in time to when our call began. And I think, Deanna, you were able to locate some information about cherry picking per se. And
Yeah, I think that what
you-
Deanna came up with that is good. I'm gonna try to.
Me too. I like it.
Yep,
Okay.
very good.
Well, why don't we,
Yeah.
we'll weave that into the existing language
Yeah.
that we've got in the opinion. We'll finalize or not finalize, but we'll get a template for the form letters and circulate those and ask you to review and comment on those at our next meeting. And I think that'll
And
give
the
us, I'm sorry, go ahead.
I'm saying the former client list is the one that we're still
Yeah,
struggling.
that's right. We're going to tweak that a little bit and offer that up for your consideration, including some language maybe about the ethical screen. So that's, I think, what lies ahead of us. And at any rate, I told Suzanne earlier I could see the finish line. We're not there yet, but at least it's in sight, I think. And Warren, we'll let you know when we meet again, because I think it's good to have you on here. But anything else that we ought to chat about here before we call it a day? And I know we've got obviously a late October meeting of the full council, and maybe if we can do something in the September timeframe, we'll have something that is worthy of a robust report.
Yeah, I'm hoping that we can get another meeting in before then.
That's right. Yep. Okay.
I'm
Anything
sorry
else?
that my little conundrum took so much time, but I'm very appreciative that Deanna gave me a little salve, saying this guys in South Carolina are just weird. That wasn't quite what she said. It is. In fact,
David, they've done you and your client wrong. That's all I have to say.
no.
Yeah.
Well, and the judge said that you're one of the finest firms in South Carolina. He had a
Yeah.
little.
That's not true anymore since I've left, but it was
That's
certainly true when I was there.
He threw you a bone.
That's a little self-serving there, Dave. But, well, anyway, this is great. It's I told Warren we've had a great set of conversations, and that continues. This is something that just creates a lot of good discussion. So thank you all for weighing in and offering your input and your insights. And we'll keep you posted until next time. We'll have some reading for you to consider, and then we'll see how far we can get next time.
Thank you, Warren and Deanna,
Thank
for
you.
joining us.
Yep.
Thank y'all
Thank
very
you
much.
all.
Yeah.
for
Great to
working.
see
All
you.
right. Take
See
care,
you next
everybody.
time.
Yeah.
Bye.
Bye-bye.